Welcome back. Today we're getting into the engine room of negligence. This video is about duty, the standard of care, and breach. If negligence were a sentence, duty tells us who owes care, and breach tells us whether that care was violated. This is one of the most important videos in the entire torts sequence. So part 1, does the defendant owe a duty of care? We always start with an assumption. Everyone owes a duty of reasonable care to others. That is the default rule. Courts do not ask whether a duty exists in the abstract. They ask whether there is a reason not to impose duty. That is a big mindset shift. Foreseeability is the starting point. The question is simple. Was the plaintiff a foreseeable person exposed to the risk created by the defendant's conduct? You do not need a relationship. You do not need proximity in the social sense. You just need foreseeable exposure to harm. That's why innocent bystanders can recover. The reasonable care principle. Once foreseeability is satisfied, the duty imposed is reasonable care under the circumstances. This is not a fixed rule. It is flexible. Courts intentionally leave this vague so it can adapt. Part 2. The reasonable person standard. Now we refine duty into something usable. The standard of care is the level of conduct required to satisfy the duty. The default standard is a reasonably prudent person under the circumstances. I'll repeat that. A reasonably prudent person under the circumstances. This is not perfect behavior. It is not hindsight. It is reasonable judgment at the time of conduct. Flexibility in the standard. The reasonable person standard adjusts for circumstances. Emergencies matter. Physical conditions matter. Superior skill matters. Mental conditions do not excuse negligence. That is a policy choice. Children get a modified standard unless they engage in adult activities. Judgment versus negligence. A mistake does not automatically mean negligence. Courts draw a line between poor judgment and unreasonable judgment. An error made reasonably is not negligence. This protects ordinary human decision-making. Part 3. Breach. Did the defendant fall below the standard? Breach is where theory meets facts. The question is, did the defendant act less carefully than a reasonable person would have? This is almost always a jury question. Courts rarely decide breach as a matter of law. Balancing risks and precautions. One of the most important breach tools is risk balancing. Courts ask, how likely was the harm? How severe would the harm be? And how burdensome were the precautions? If the burden of the precautions is less than the risk of harm, failure to act may be unreasonable. This is not math, it is logic. Categories of precautions. Precautions can be durable safeguards, temporary actions, warnings, and supervisions. If a precaution was easy, cheap, and effective, failing to take it looks unreasonable. Part 4. Custom and breach. Custom is evidence, not law. What others do may help the jury understand what is reasonable, but customs does not define the standard of care. Some customs are bad. Courts are clear on this. What is usually done may be evidence of what ought to be done, but it does not control. Both deviation from custom and compliance with custom can matter. Safety statutes and breach. Negligence per se. Sometimes legislature steps in. If a statute sets a safety standard, courts may use it to define duty and breach, but not every violation equals negligence per se. The courts ask, was the plaintiff in the protected class? Was the harm the type the statute was meant to prevent? Was the violation excused? Depending on the jurisdiction, a statutory violation may be conclusive breach, presumed breach, or just evidence of negligence. This matters a lot on exams. Proving breach. Direct, circumstantial, and res ipsa. Plaintiffs rarely have direct proof. Most breach cases rely on circumstantial evidence. When the plaintiff cannot point to the exact failure, res ipsa loquitur may apply. Res ipsa allows the jury to infer negligence when the accident does not normally occur without negligence, when the instrumentality was under the defendant's control, and if the plaintiff did not contribute. This doctrine shifts pressure to the defendant to explain. Professional negligence. Professionals are judged a little differently. The standard of care becomes what a reasonably competent professional would do under similar circumstances. I will repeat that. What a reasonably competent professional would do under similar circumstances. Custom matters more here. Expert testimony is usually required, but professionals are not negligent just because a better choice existed. Choosing between accepted methods is not breach. Putting duty and breach together. Here is the exam mindset I want you to adopt. Start with a general duty of reasonable care is owed, then ask, is this a limited duty situation? Are there exceptions? Is there a special relationship? Does policy cut off duty? If duty exists, move immediately to standard of care and breach analysis. If you get duty and breach right, causation and damages become much easier. Duty and breach are not about memorizing cases. They are about structured judgment. Courts are deciding what behavior society should expect from people towards one another. Next, we're going to move into causation, and that's where things get a little bit more precise, and then damages, which completes the negligence framework. I decided to add on a little bit more to this video just to have a more fuller idea of duty and breach. I want to talk about owners and occupiers of land in this video as well. So let's talk about one of the most tested duty exceptions in tort law. Landowners and occupiers do not owe the same duty to everyone. There's 3 different standards of duty that they owe to people that are on their land. And this duty depends on why the person is on the land. This is one of the few areas where duty is determined by status. So the 3 categories of entrants, traditionally courts divide entrants into 3 groups, and that is invitees, licensees, and trespassers. Each group gets a different level of protection. So invitees get the highest duty. Invitees are people invited onto the land for business purposes or because the land is open to the public. So think customers, patrons, students, patients, and of the like. The landowner owes invitees a duty to use reasonable care, inspect for dangerous conditions, fix or warn dangers the owner knows about or should know about, and this is the highest standard of care for an entrant. The middle duty is for licensees. So licensees are people who enter with permission but for their own purposes. So social guests are the classic example of licensees. For licensees, the owner must warn of known dangerous conditions and that the licensee is unlikely to discover. There is no duty to inspect. The key difference from invitees is knowledge. Trespassers are owed the lowest duty of care. Trespassers enter into the owner's property without permission or legal right. Landowners generally owe no duty to inspect, but they must not willfully or recklessly injure them. However, once a trespasser is known or anticipated, the duty increases slightly. The owner must warn of known artificial conditions that pose a risk of serious injury or death. So child trespassers and attractive nuisance. Children get special treatment. Under the attractive nuisance doctrine, a landowner may owe a duty to a child if the child trespasser, if there is a artificial condition that exists on the property that the owner knows children are likely to trespass, that the condition poses a serious risk, that the child cannot appreciate the danger, and that the burden of fixing the condition is small compared to the risk. This is a big exam favorite. So the modern trend in many jurisdictions have moved away from the rigid categories, and some apply a general reasonable care standard to all entrants with status as one factor. California is a prime example. On exams, always identify the traditional rule, then mention the modern approach if relevant. Landowners and third-party crime. Landowners may owe a duty to protect entrants from foreseeable criminal acts of third parties. Courts use different tests: prior similar incidents, totality of the circumstances, and balancing tests. This usually applies to invitees. How this fits into the duty analysis. Here's the big picture. Land status does not replace the duty analysis, it refines it. You still start with a general duty of reasonable care exists, then ask, is this a landowner case? What is the plaintiff's status? And are there special rules or exceptions? This keeps your answer organized and correct. So I just wanted to add this on to the duty and breach video, and I will redo my closing and ask you, if you have any questions, please leave them in the comments or message me on any social media platforms that I list here. I am open to any questions that you may have. I hope this helps. It's a little complex. It's a lot to go and memorize, but again, I don't suggest you memorize anything at this stage. I am creating these videos to kind of create the framework that you need to pass these exams, and I'm here to help you and hold your hand through law school. So like, share, and subscribe, and let me know if you have any questions or any additional videos I may need to create. Thank you.